You're listening to Planet Green Trees. The call number is 1-347-326-9626. We have an hour and 29 minutes left, and we are right on schedule. Our next guest, as we mentioned, is the lawyer for the Green family, attorney Joshua Covert of the Nichols Law Firm in Lansing. The Nichols Law Firm is really one of the premier law firms in Lansing. I know they also are the leading edge of drunk driving law and anything dealing with traffic offenses and intoxication or impairment. But with that being said, we're going to be talking right now. Joshua Covert, welcome to the show.
Thanks for having me. My pleasure.
My pleasure. This has been very, very distressing to a lot of people that hear the story. Before the show, I was talking to a caregiver friend of mine and was asked the question when they saw it on the news, is this what's going to happen? Are they going to come in and take our children too, husband caregiver? What is that what this case is about? Is it really that outrageous?
It is, yes. Medical marijuana patients and caregivers need to be concerned about this. It could happen to them.
Let's talk procedurally for a second. I know that there's a couple of different players here. This wasn't an investigation that was initiated by the state initially. Is that correct?
That is correct. It's our understanding that the allegations that initiated the investigation were from Maria's ex-husband.
Right.
And it was interesting. Yeah, go ahead.
No, please go ahead.
It's interesting that happened the day after a court proceeding. Told her ex-husband that he needed to stop following the court order and providing parenting time to Maria. Then the next day, the allegations were made, which obviously puts the integrity of the allegations into question.
Of course, and there is, it's always unfortunate because the field of law that we're talking about right now is really one of the most distressing. The divorce and custody and visiting time and all of those things. And when you have strange people that are strange from a relationship, one of the tactics is they use the children as a pawn, without question. But I think it's an important point of this case that it was not an investigation initiated by the state per se. It was a person that probably most likely sounds like it was lacking in any kind of real authentic reason for the interest of the kids. It was more to mess with the ex.
Correct. Yes, that's exactly how we feel.
What were the allegations more specifically? What was the ex-husband or the child's father? And is Bree the child of the father?
No.
Wait, right.
There are two children that are involved with this. There is Elliot and Brielle. Elliot is Maria's child with her ex-husband. Brielle is Steve and Maria's child together.
Right. So that's how it originally started. The drawing of attention to the Greens came from the embittered ex-spouse over really a responsive pleading of parenting time. And his response was he threw back, something about the medical marijuana. And then CPS came and wanted to investigate. Is that how I understand procedurally things happen?
It's correct, yes. They started the investigation. They started by interviewing the children individually. There are also 3 other children that were initially involved. Those were Steve's children with his ex-wife. That petition to remove those children was denied. The only petition that was granted involved Elliot and Brielle. So they interviewed Steve's children from his previous marriage as well as Elliot. Then they contacted the Greens, and that's kind of how it all started.
Okay, so I think for procedural purposes, and a lot of people are probably interested in this, why don't you explain the rights and privileges that an individual has who is parents, who is a parent, and what their rights are in these instances. I mean, I can offer my thoughts on what I believe the law says, but do you have a specific opinion? Let me ask you a couple questions. Let's say CPS. What's that?
Go ahead. Yeah.
Let's say CPS calls a parent and says we have a complaint and we want to come talk to your child. what is a parent's? I mean, can a parent say no? Can a parent have a lawyer there? Can a parent have the lawyer present with the child?
In this case, no. They went ahead and interviewed him at school, and there was nobody there other than the CPS worker and the child. My understanding that even school officials cannot attend the meeting.
I agree with that, and they can do that. However, you can request a lawyer, but if they're doing it under the auspices of an investigation dealing with the well-being of the child, they've granted certain other abilities. Unlike a law enforcement agent, for example, that would be questioning a minor, they would have to have a parent or guardian there, right? We would agree about that.
Yes.
And so they interviewed Elliot and the children from Steve's previous relationship, and that was done without them knowing, probably, and in secret possibly. But nevertheless, it ended in no action being taken. Is that right?
Correct.
And then they turned the investigation to the other two children, Elliot and Bree. Is that right?
Yes.
And the concern of Elliot, the older child, was because of the embittered ex of Maria's, and but then somehow they got to Bree. So let's talk about that. So did they schedule an appointment to come to the Greens' house and want to talk to them, and how did that play out?
They came over to their house, knocked on the door, and wanted to schedule a time. Or actually, they just wanted to enter the home and inspect the home to make sure that to complete their investigation. The problem that arose with that is that they wanted access not only to the home but to the grow room, and that's a problem because the Medical Marijuana Act and lots of case law clearly states that the room can only be accessible to one person. And if they were to allow anybody else in that room, they would be, in essence, violating the law and subjecting themselves to potential criminal liability. And, the Greens know the law, and they follow the law. And they knew that they couldn't allow even a CPS worker inside the grow room. But what was also alarming was that the CPS worker wanted information on the patients that Maria is a caregiver for. She wanted to know what medical conditions they had and to see medical records and that sort of thing, which also could, possibly subject the Greens to some sort of liability in terms of maybe violating HIPAA laws or that sort of thing.
Understood. I wonder, though, if it was the CPS worker that was alone, or was there somebody else with them? Was there a law enforcement agent?
There was not a law enforcement agent, no. We really invited them to get a court order to get in the house and to see the grow room.
No, let me ask you this. Okay, so how much of but independent of the belief, whether right or wrong, of that was the right thing to do, and I'm not saying it wasn't, but independent of that, was this the reason for them? Was this one of the principal reasons that they were? I mean, I could see. I'm not saying that it's right. I'm not saying that they have a right to get in there. I'm just wondering, is this the basis by which the removal comes about? In other words, are they suggesting that they're not allowing the investigation to take place? Are the allegations such that they're hindering the investigation to be able to determine if the home itself is appropriately safe? Is that one of the allegations?
Yeah, well, I mean, the Greens were perfectly okay with showing them that the home is safe. They just wanted the understanding that they would not be able to access the places of the house the law would not allow them to access, being the grow room, and then they weren't satisfied with that, CPS. That's not something they would agree to. So originally, they had an hearing last week on Friday, and that was when Brielle was taken. That originally was going to be a hearing for them to petition to gain access into the home, which we were in support of. But then that morning, they called and said, well, no, now we're not going to petition to gain access. We're going to petition to remove the children.
And
so it did start that way, but they changed this morning in the hearing.
And they being the CPS who files these actions with the with the referee, but there's a circuit court judge that has the final say in all this. All right, so so there's not been a finding that CPS can have access to the home, but instead there was a finding that by the referee that Bree should be removed, not the other child, not Elliot, right?
Elliot wasn't at the home at the time, but yes, he was essentially removed as well. That he is not allowed. Maria is not allowed to have him at that home as of right now.
Are there other children living at the home that have been found for it to be okay for them to live there?
The other 3 children do not live at the Greens home, other than
Okay. Can you still hear us? Went out a little bit there.
So there was no change in regards to those 3.
Okay. And what were the principal allegations in this instance? I mean, was it specifically that we asked for access, they said no, therefore the child must be removed? Is that how?
They brought up additional allegations, and it was that because marijuana is grown in the home, the children are in danger. And the reason they say they were in danger was because somebody could rob them, and that they're a target for robbery because they grow marijuana in their home.
So it wouldn't have mattered. So what you're saying is it wouldn't have mattered whether or not they were able to get in or not, because just the mere presence of marijuana in the home was going to be the basis by which children were going to be removed. Is that right?
Correct. Yes, that was the referee finding. There was also allegations of smoke in the house, but there was testimony taken at the preliminary hearing that it wasn't smoke of marijuana smoke that the children had talked about, that it was a vapor from a product the Greens have formulated and created called Canology, which does not contain any THC. It's a mixture of essential oils of other herbs like hops, lemon peel, and that sort of thing. And so the Greens do demonstrate the product at their home when potential customers come by. And that is what we believe what the children had discussed with the CPS workers, was that there was smoking in the house, but it's clearly not marijuana smoke, because both Maria and Steve have been testing clean for THC, and that's something we provided at the preliminary hearing, was drug testing results showing that the Greens are not using marijuana.
I'm still caught up on what happened to them needing to get in the house. How was that dropped? How was that was it just over? It's not something being talked about? And does it make a difference now? For example, let's say he made a different decision to let them into the grow room, hypothetically. Are they going to get the kids back, or are we beyond that?
I believe even if they had seen it, that they still would have proceeded with the allegations that because you grow marijuana, you shouldn't have children in your home because you could be robbed, which I think is ridiculous. People that have expensive jewelry, electronics, antiques, those sort of people are not in any more danger to be robbed than somebody that has marijuana plants. I would argue that they're probably more likely to be robbed. Those sort of people don't get involved in CPS. Those people don't have their kids removed. And so I find it ridiculous of the allegation that just because somebody grows marijuana in their home should have their children taken away. I think that was contemplated when we as people initiated and voted for the Medical Marijuana Act, and that's why we protected cardholders from any penalty in any manner, with the one exception being 4C, which states that custody can only be taken away from a parent if there's an unreasonable danger that's articulated and substantiated. Our position is that this was not an unreasonable danger. It's no more dangerous, like I said, than people that have expensive jewelry and electronics and so forth.
Well, I don't know if you heard me ranting at the beginning of the show. I agree that there's this fallacy that has been, it's almost as if it's been transferred from this other issue regarding the outdoor grow or the indoor grow, even the concept of an enclosed locked facility. I've had many, many cases where officers have, determined that the facility wasn't locked and enclosed by their own, own personal view. There's no guidance for them, but they just say it's not locked and enclosed, and their justification may be, anyone could get in there. Someone could easily walk onto the property, shoot the dog, rip down the sheets that were, hanging over the cattle fence, put their arm in, and pull the plant out through the fence. Well, of course, if someone could break in someone's house at any given time. And the idea that the enclosed locked facility must protect against trespassers, against, people that are going to break and enter into someone's home and go into their basement or wherever, or even go into someone's property and steal property from someone. The idea that is a requirement of a United States citizen ever to be in compliance with the law, you will not find a precedent in American jurisprudence. And it seems as if that's what's really going on here in this particular instance. That the premise being that it becomes dangerous, like you said, owning valuables at all, it becomes an unworkable definition here where, by in and of itself, it's like a strict liability. You're in violation of it. And there's an inherent problem there. And, what's the solution? Is there a workable, do you have to have your child in an enclosed locked facility to protect them from getting robbed? Is that what they're suggesting? You know what I mean? Like, how far is it supposed to go? What are we protecting against? What, if he had some kind of, very expensive security system to, so that what? So there was some kind of notification that went to the local police so they could come and stop the robber that might be breaking into the house. Would that make a difference? The same argument can be made for the outdoor grows. I'm just, makes it unworkable. Now, is their underlying position that nobody can grow marijuana? Have they gotten that far?
I think that's where it's going. Yeah, I think they're trying to set that precedent.
Well, you were in the you had a referee. Go ahead and name his or her name. Feel free to let the world know who may be voting in Lansing area that. But they're appointed anyways, aren't they? The referees. It's paying.
Yeah.
Nevertheless, their rulings and opinions are really, they can be. They're not final. Like all the rulings can be appealed to the circuit court judge, who will have an opportunity here. And I'm assuming that's where this is going next, right?
Yes, earlier this week we filed a request for review under NCR 3.991, which allows us to request the judge to review the recommendation of the referee.
What's the standard of review? Are you entitled to present evidence, or is it purely like for error?
No, we are able to present evidence. The judge can either reject, accept, or modify the referee's recommendation, and we can present additional evidence that was not presented at the hearing. And that's something we will be doing.
Let me ask you this: was there a written order by the referee?
There was. Yep.
Does it address, I know for custody, there was 12 or 13 points that the court will consider in terms of, they have to articulate each of the points in order to validate a removal or a change of custody. Were any of those things addressed in the order?
I don't have it in front of me right now. I'm in the car right now.
I understand.
With the green. But they did not. It was a form that the referee filled out. It was really easy for him to do. He just had to check a couple boxes, and the child was taken away.
He doesn't explain it, in other words. They don't really go to great detail, like
stating the danger about being robbed.
Right. And who is the circuit court judge that you're supposed to appear in front of, and what's the date of that?
Richard Garcia is the judge. We're scheduled there tomorrow at 3:30 in the afternoon.
Okay.
And we'll be asking him to reject the referee's recommendation and return the children.
Do we have any beat on how frequently the circuit court judge will overrule the referee?
I don't know. That's a tough call. He didn't even have to give us a hearing on this matter according to the court rule. He could have just sat at his desk, looked at the review, and been like, yeah, this is cool. But he actually did give us a hearing on the matter. And he's going to allow us to present evidence and oral arguments, which isn't required to do either. So I am hoping that that's a sign that things will go well tomorrow.
Right, you want to at least have your day in court. And if I understand that there wasn't a lot of argument, I mean, didn't they pull some shenanigans as well? Like you were coming from another court, they changed the schedule.
I was. Well, they told us at 4:00 on a Thursday to be there at 1:00 on a Friday. I had a previous engagement, a court appearance in Detroit, and I wasn't able to switch that around. So I had to go to Detroit. But I told the Greens that I'm on my way. I'm going to be there. Tell the courts to hold off. Have them call another case. I will be there. I arrived at the courthouse probably 5 minutes after the order was signed. They gave him a court-appointed attorney that really didn't know anything about the facts and what was going on with the case. He had just been appointed right then and there. I
know that story. I mean, there's courts that operate like that, and I talk about the brutality of the system, and that's a ruling from an individual who's never practiced law a day in their life. I'm guessing that this referee has never had to pay a light bill or be in more than one place at the same time, or ever have to tell a client if there's good news or bad news.
Didn't they have this referee have a bad experience that may have driven his decision in this case? Is that what we would
I'm just saying, listen, we are brothers and sisters of the law. We're all trying our best. We all have families. You don't do something like that to an attorney unless you are the type of judge who's just never practiced law in your life. You don't go after a lawyer. You don't take a case like this and throw it off to as if you're not going to be there, And the point of it is that sometimes lawyers have to be in more than one place at the same time. It means that they're a good lawyer, that people want them, that they're working. You got a lawyer that's sitting in the court. They've got one case. It's your case. I mean, I just, it's one of those situations where, in addition to the terrible logic, reasoning, and ruling, they really, did the profession wrong by not honoring your appearance, your client's right to have the attorney of their choice, which is a constitutional right. That seems to be even more troubling. This is there a background on this referee? Or is Rick just pulling my chain?
Yeah, I really don't know a lot about this referee. That was the first time I've been in front of him. I really don't have much to say about him.
So let me ask you this: I don't want you to give away your hand, but what are the principal points that you think are going to carry the day? I mean, obviously, reason and logic and the protection of the law and the ridiculous logic that's being used here to draw these conclusions. I mean,
Yeah.
Is there? I don't know. I mean, is there? I don't know if there's statistics that would support the idea that it just doesn't happen, or I mean, there are things like that. I don't know. Even though, you have no idea where this judge may be coming from. The understanding of the law and or what their level of understanding is to even But let me ask you this: if a situation comes up about allowing inspection, is that position still stand, or would you offer to the judge, look, if you enter an order, where my clients are compelled to, they don't want to, create a circumstance that would subject them to arrest for one reason. And look, Judge, we've said that all along. In fact, when we were here last week, that was what we thought the intentions was going to be, and from there we were going to simply, allow access, not a court-signed order, limiting my client's liabilities. Right? I mean, that's something that would be probably in play, wouldn't you think? We may have lost him. It's a good question. Oh, he's back over here, I think.
Lost signal calling back in.
I see.
Interesting stuff, though.
Sorry about that. I guess we lost. Josh, you still there now?
Yeah, I'm back. My phone cut out for a minute.
Not a problem. Did you hear I guess I was kind of like making an argument on your behalf, on behalf of the Greens too. Just, I mean, the issue of inspection at this point, putting the giving access versus getting the kid back, so long as there's an order in place, resolves that issue, which was originally the issue, right? I mean,
yeah.
Is that still remain? Is that something that's going to be part of the presentation tomorrow? I mean, I'm just curious. That's
going to be a big part of it tomorrow. Is that we've tried to cooperate, we've tried to be reasonable, but we're going to follow the law, and the law says that only one person can access the room, and the Greens were in between a rock and a hard place. It's either break the law or we take your children, and I don't think that anybody should put in that situation to make a decision like that. Because by breaking the law, it could give them another reason to take their children away. So it's kind of like we take your children away or we take your children away.
I understand. Let me play devil's advocate for a second. Don't think that this is my position. If he did let him in and he's in compliance and they leave and the issue is resolved, just hypothetically, from the devil's advocate, the way in which trouble would befall them from that point after would be that CPS worker would walk outside, get on their phone, and call the police and say, "There's not a locked and closed facility here." Right? That's what essentially would have to happen. I'm just saying,
they think accessible to only one person.
Right. I mean, if they would have, and if the police came and they say, "What? We have reason to believe that you let a CPS worker in here and violated Section 4, therefore we're taking all your plants and seizing all your property, and and they're in compliance with the law." I mean, if they do that, they've got a bunch of I don't know if both of them were home at the time. I would have videotaped the entire thing, but was there any videotape taken or any audio recordings? I would think
there was not. No.
I'm just wondering, just in terms of I know I feel where the principle's coming from, but the law, it's outrageous in that regard. And I don't know. I hate the idea of that being the pitted issue. And then what is how does the other way play out? I mean, do you think that I don't know, is that a probable cause? That the basis of the violation of the enclosed locked facility is that a CPS worker? I don't know.
Yeah, I think it could be. I mean, that issue hasn't been settled, but as far, as I read the law and the case law, it's been very clear that it says one person. It doesn't say one person or CPS workers or one person or law enforcement. It says one person. And that's something that, we're standing behind and following the law as it's written and as it's been interpreted.
I know. I mean, it's I know, and I know there's no exception. I'm just wondering, to me, because it's interesting. I was talking about this last week a little bit because I would say the majority of cases, that I'm currently working on are cases that involve alleged violations of the enclosed locked facility. You know what I mean? And it's things like two people growing together, or plants weren't separated, or there wasn't a super duper locking mechanism, or as I described, the police officer says it's not locked and enclosed. It's anyone can walk onto the property and break the law, and it seems to be a real basis by which, because it's other than, and the cases that have analyzed the enclosed locked facility really haven't analyzed what enclosed locked facility is. They've given us definitions. It's described what possession means, and no collective grows, but it didn't say this is locked and enclosed, this is not. In the Balsma case, they said, well, he had too many plants, therefore he can't be protected by Section 4. The Larry King case, it was about a dog run that was loose. He said in this case that's not what we're really talking about here, but it's really about two different sections of the act, and even though he's outside of the enclosed locked facility, he's allowed to present his defense. But what's interesting is I'm against the idea. I just am not, in rereading Balsma and especially Section 4D, which is the reference to the presumption. And what it says is that, you go through 4A, patient, you go through 4B and 4C, and 4D says that assuming that the patient or caregiver has a card and has the amount of marijuana that they're lawfully allowed to have under the Act, a presumption exists that they're in compliance that can be rebutted by, evidence of non-medical use. Okay, so what I'm saying to you is that, we know that the restrictions of Section 4 of what Steve is, fearful of, and people should be fearful of, because it's, violations of the enclosed locked facility that are getting people dragged into court. As silly as that is, technical, silly violations. Take down a whole grove. Total incompliance, patients relying on it, your doors unlocked, whatever, they're taking them down. It's ridiculous. And my point is that I mean, my rereading of Balsma tells me that you can't call violation of Section 4 because of an enclosed locked facility. That in order for you to say someone is not in compliance, they have to either not have a card or have too much marijuana. But if they're in compliance, they have a card and their door and it's not locked and enclosed according to the police officer, you can't arrest. That there's a presumption, and only if they've got some evidence of someone selling it illegally or something like that would it then be justifiable. I mean, I don't know if you understood anything that I just said there, but the point is that the use of this enclosed locked facility violation has been an abusive loophole for the law enforcement community, and people should not be put in that situation, as Steve Green was and his wife Brielle, and it's very, very unfortunate. I don't know. Do you have any thoughts on that and that interpretation? I don't know if you followed me on that. If you knew about that Section 4D that I'm talking about just off the top of your head, I'm not trying to test you on it, but
I agree wholeheartedly that the presumption that they're in compliance is important in something like this. And I think in this case, when the CPS workers saw the cards, there would have been no reason to go into the room because there is that presumption that they're in compliance. And without some sort of allegation that there's something that they're not complying with, they're presumed to be in compliance. So I agree with you wholeheartedly.
Yeah, I mean, it's something that's been unfortunately abused as a basis. I don't know. I always talked about a much better approach. If I'm not talking about the Greens, and I'm not suggesting it, but if there's, the civil fine, or, someone's got an enclosed locked facility, husband and wife are growing together. I mean, use some discretion. Yeah. You know what I mean? It's like, make it workable. And I can't
help them out. Give them a warning. I agree totally.
I mean, there should be, it shouldn't destroy it. I mean, and the other thing that we clearly know people are not allowed to lose their rights unless there's some other reason, right? I mean, they've got to have another reason. Absent a showing of some kind of behavior. It's not even bad thoughts. It's behavior of, non-medical marijuana use. None exists in this case. Then they're presumptively acting in compliance. So I don't know. It's very, very in case I understand we have one of the Charmie is supposed to be on the phone. Did we figure that out, producer man?
He needs to have his own intro music. Producer man.
I'm going to try this. I'm going to go on a limb and see if this is who we think it is. Charmie, is that you? Charmie. All right. This is what we're going to do. I know the Greens are with you, and I want to keep you on the phone, Josh, and I want to hear from Steve and Marie if they feel like talking. And it is just an awful abuse of the law. I mean, it's I did see the comments of the spokesperson from the agency who snidely, I would say, said it's the decision making, something to that effect, like bad decision making, such as the decision to be a caregiver or the decision to be a patient is going to be determinative upon a person's right to have a child in their home. Who is that person? What an awful person. All right, this is what we're going to take a break. We're going to try to get Charmie on the line, who was the producer and really the sponsor with Michigan's Moms United. Michigan Moms United, right. And the event this past week, we want to hear from her. So we're going to take a quick break and be back. We have about 53 minutes left. Listen to Planet Green Trees. The call number is 1-347-326-9626. We've been talking to Josh Covert regarding the tragedy in Lansing regarding the Green family. We're going to take a break and we'll be right back.